Hello, hello, hello. This is Attorney Mike Gravelin coming to you from Chicago as usual. And today we've got the gripping finale of the Dog Days saga. Judge Simpson gives his ruling on this. For those of you who don't know, you should really start at the beginning. I have a playlist. I'll put that somewhere. I'll put a card up or in the description. I didn't do it yet, but there's a playlist called Dog Days. This is the fourth video. And what's interesting in this is there's this wacky dog attorney. I don't know her name to this day. I've watched all these videos. I don't know her name, but she tells her client to claim ownership of dogs, which puts him in line for at least one felony charge and multiple other charges, as well as civil liability. It's horrible. The judge is can't believe it's happening in front of him. But we've had a whole bunch of hearings. There's even stuff before this, but they took it down. But a lot of you have been on this journey with me, and this is roughly speaking the conclusion of it. It's the conclusion of the civil matter, at least for now, and the whole event isn't over because there's pending criminal charges, but it does inform what's going to happen with those as well. So let's just get it started.
Bernstein is now here. Counsel, state your appearances, please.
Good morning, Your Honor. Chief Assistant Prosecutor Victoria Bird here on behalf of the people.
Good morning, Your Honor. Sam Birdstein, on behalf of Ms. NULL for all matters.
Good morning, Your Honor. Celeste Dunn, Mr. David Moor.
Right. We are specifically dealing initially in the case of the people of the state of Michigan versus Catherine Null, that being the civil action, which is going to have some bearing on the felonies that have been filed in the court's decision, and based upon Ms. Null's motion to enforce the order regarding the surrender of the animal. I will put it this way because I don't want the same argument that this court has spent hours hearing. Is there any additional argument on behalf of the people?
No, from the people, Your Honor.
Mr. Bernstein, it is your motion. Is there any additional argument?
None on behalf of Ms. NULL, Your Honor.
Ms. Dunn, is there any additional argument?
No, Your Honor.
All right.
Well, apparently her name is Miss Dunn. At least that's who I think it is, the wacky animal attorney. And I was shocked and floored when I first saw this. This was this morning, by the way, and I edited it down for you. But I was shocked and amazed that she did not argue here. She's not intervened on the case. She has no business arguing here, but that hasn't stopped her in the past.
On this matter in the court, and again, this involves the specific order which was entered by the court previously, and the respondent knows request that order be enforced and that order remain in place. The court had executed that order after I will describe as a lengthy hearing, which ultimately resulted in a settlement between the parties. Suffice it to say that the fundamental issue, which was then raised based upon a cease and desist letter which was sent to the Humane Society, was the issue of ownership of these dogs. That is, as it regards all of the other 20 cases that have been filed, is central to that, as to who the owner is in this case and who would have the authority to surrender the animals, as Ms. Null has done in this case. And Mr. Miller has come, albeit late to the game in certain respects, and objected, claiming that he has some ownership interest. As indicated, there's no dispute that Ms. Null claims ownership, either in full or in part, and has surrendered those rights to the Huron Valley Humane Society. Mr. Miller's posture in this case is a bit circumspect in certain respects because he is not a party that has properly intervened in this Null matter, but has had an opportunity to the extent that it may implicate vindicate some due process rights to address the court on numerous occasions and to participate in these proceedings. I would indicate that while counsel for Mr. Miller claims that the statements to the court were made, the statements that Mr. Miller made to the court were made without his knowledge of the
I wouldn't doubt it.
dog law of 1919. With all due respect, the court does find that these arguments are without merit. Certainly the court believes that those arguments are disingenuous and they border on spurious.
Disingenuous, bordering on spurious. That might be a new T-shirt.
Given that even a child knows whether they own something or possess or have the right to possess something, they know whether or not something is theirs. They don't need a lawyer. They don't need a statute to tell them otherwise. Even if it ultimately their conclusion of that may be wrong, certainly the statements they make are clear as to their indication and to their status. As I've alluded to before in numerous hearings regarding the dog law of 1919, where it has been raised that there is this definition of ownership. And I've alluded to the fact that that statute specifically relates to the responsibility of those that have dogs. It is an old statute. It also, this court doesn't believe under these circumstances, stands for the proposition that the respondent Miller, defendant Miller, is proposing, without even necessarily going into the legislative history behind that statute where a court doesn't need to where it's clear. And while the introductory language is not certainly part of the statute, it does clearly point out what the purpose of that legislation was. You know, read it specifically. It says an act relating to dogs and the protection of livestock and poultry from damage by dogs, providing for the licensing, regulating the keeping of dogs, authorizing their destruction in certain cases, providing for the determination and payment of damages done by dogs to livestock, poultry, imposing powers and duties on certain state, county, city, township officers and employees, and to repeal a previous public act provision, and then providing penalties for violations of the act. And that's the introductory portion of the statute. The statute then goes on to provide definitions, talk about licensure, leashing of the dogs, and the like. It does not, as Defendant Miller indicates, specifically address how to resolve the issue of ownership. It's not designed to do that. It is designed, particularly with regard to its definition of ownership, to provide for remedies against people who are in violation of the act, where damage is done, where they don't license, where they don't leash the dog, and the like. But does nothing to establish true ownership of the dogs. As I've indicated, that statute really just places regulations and certain burdens on those who may have and or possess dogs. Frankly, this case, as regards ownership, is more akin to an ever-increasing concept that is coming forth in our courts regarding dog custody in divorce cases. Who owns the dog? Whose dog is it? And in reviewing numerous cases, courts have used certain criteria to determine, outside of what might be love and affection, because I'm not really deciding a custody issue, I'm deciding ownership. But in terms of ownership of whose dog it is, the courts have used various things. They've used veterinary records. They've used spay and neuter records. They've used other care records, which may be if the dogs are taken to groomers, who takes them to the groomers. Those who have done things either in writing or otherwise that show indicia of their ownership. In this case, when one is looking at ownership of the dogs, everything provided to this court in terms of the spay and neuter records of the Huron Valley Humane Society, where the animals were taken for their rabies shots, as well as spay and neutering services, clearly and unequivocally indicate that the owner of the dogs, as listed, is Miss Null. The records regarding licensure with the county, of which the rabies vaccine records would have had to have been provided, indicate that in regard to the 4 dogs that are present here, or that are at issue here, are Miss Null. She explained certainly that she did it, but those are the records that are in front of the court. Every piece of paper, every bit of documentary evidence regarding the dogs at issue in this case are all in Miss Null's name. I guess in certain respects, it just is what it is. That's where they are. There has been some indication that since they live together, that there is some type of joint ownership. Well, I guess people could live together and maybe there could be joint ownership, but there are also people could live together and the dogs belong to one party and not the other party. But I'm not here to even decide that issue. I'm here to decide who are the owners. Most importantly, however, well, not most important, when I take those particular items, all of the documentary evidence indicating that Miss Null is the owner, and that up to the point that the order was signed, there was no indication to the court to the contrary. And I think that's important to point out, because anything that came out to the contrary was as a result of Mr. Miller and his cease and desist letter that I would note it was really the first time that this court, and this was a day or so after the order was signed, where he indicated, intended to indicate that he was the owner of these animals. But one has to look at the documentary evidence along with what are Mr. Miller's statements prior to the order. I will say that prior to the order, somewhat truthful statements, somewhat not on behalf of Mr. Miller. Certainly at the time of the hearing, there were statements that, quite frankly, in this court's mind, were all self-serving. And in certain respects, it is very difficult to give much of what the testimony of Mr. Miller stated any credibility. And by way of example, Mr. Miller made a representation to the court because at the hearing that occurred on March 22nd, his fundamental focus was about animals on the property. And he made a specific representation to the court that he was the owner of the property and was attempting to try to object on those grounds. It was later determined that Mr. Miller isn't the owner of that property at all. And frankly, although it's not called upon at this time for this court to rule on it, would have no standing to even raise the issue per se, at least not in the way in which it was attempted to be raised before the court. But going back to my main point, I have the registration, I have the vet records, I have everything indicating that Ms. Null is the owner. Even the Ms. Null entering into the agreement on that date, where she, if not specifically, certainly by implication, represents to the court that she has the authority to do this. Mr. Miller on that date, and I would direct the parties to page 105, specifically his statements Mr. Miller's statements to the court, and I'm referring to line 7 through 10. Mr. Miller very clearly states, I don't know about the forfeiture. I hate to see the animals put down, Your Honor. And then says unequivocally, I am willing to surrender those animals, but I cannot accept. I just, as the property owner, I cut him off with sir. And then Mr. Miller continues, I can't. And then I said, sir, I'm not asking. And he says, okay. And then I indicate, continuing on with my previous, I'm not asking anybody to accept anything. Mr. Miller goes, okay. Then told him about a resolution of the case. What was very clear to the court is he was talking about, because he goes on further to talk about what he perceived as limitations on the property. It's clear what he's talking about. And that was his focus, sir. But his statement saying, I'm willing to surrender those animals, is just not some statement he made out of the blue. He understood exactly what he was saying to the court in that regard. Word of knock, one fast forwards in the transcript to page 113. And again, as I've indicated, Mr. Miller's claim regarding ownership or entitlement in these animals was not raised till after this hearing. But on page 113, starting at line 6, with Mr. Miller's statements, as he's addressing the court, he says, quote, Your Honor, those are her dogs, and she has that decision. It's not my decision about that. He then goes on, as I'm indicating further down, starting at line 10, just says, just asking about my property. I don't think, ladies and gentlemen, it gets any clearer regarding who owns these dogs. Despite any self-serving statements that may come up afterwards, it was clear certainly on that day. And then in the subsequent hearings where the court received the evidence of things that had occurred prior to that day regarding whose name was on all the records for the dogs, that the owner of those dogs, Miss NULL, would then be this court's ruling that as to her ability to enter into that agreement, to agree to surrender those 4 animals to the Humane Society of Huron Valley, her authority to enter into other terms that were contained within that agreement regarding certain limitations on her regarding the ownership of animals, and Ms. NULL had absolute authority to do so. I would also note, while not part of the record, but the court was watching the proceedings, and I think it bear noting that the court, and I think Mr. Bernstein had indicated this, that the court had provided a room so that all of the parties could talk. And prior to the statements made by Mr. Miller, that Mr. Miller was here present in court, had an opportunity to speak with Ms. NULL regarding what she was doing in it, which may have been the reason he led to, that in part led to his state. He knew exactly what was going on. It wasn't until afterwards that he did. It wasn't until after that fact that, quite frankly, Ms. NULL's statements to the court and other things changed slightly. I will give Mr. Bernstein all the credit in the world for reconciling those before this court. And I think that he's done a great job in doing so. But it still does not change this court's mind. And the court is very clearly pointing out in this decision that as to Defendant NULL's motion to enforce that order, the court is going to grant that motion. That order will be enforced. The court is specifically ordering that these dogs have properly been surrendered by their owner to the Huron Valley Humane Society.
So he's giving his ruling, and it's pretty clear. But don't worry, wacky dog attorney. does find a way to interject herself into this situation.
That those dogs are now the property of that facility by virtue of the owner's agreement and my order, that no one shall without any other higher court order interfere with that, and that the disposition of those animals and the proper disposition, whether it be adoption or otherwise, rest within the sound and sole discretion of the new owners of those dogs, the Huron Valley Humane Society.
Well,
Counsel for the defendant will prepare that order indicating those last terms. Counsel for Ms. Null will prepare that order. And that is the entire ruling of the court.
Clarification, that order will be entered under all case numbers?
It will be entered on the case number in which the court is ruling.
Oh, that's subtle, but the level of stupid is high. That's wacky animal attorney asking if this is on all the case numbers. He's got a motion on a civil case, and he called it. There's one case. It's the civil case, and he's granting the motion, saying that the agreement shall be enforced. Okay. That question just shows she is clueless. First of all, she's not intervened. She's not in on this case. And then she asks a question on all case numbers. No, the criminal matters haven't been called. And if you're an attorney, you should kind of know that. And he isn't too bad about it, but you can see how irritated Judge Simpson is even by the question.
The court is ruling on a specific motion that was filed by Mr. Bernstein on behalf of Ms. Null in her case. That is the order that will be entered.
I have it under all the two civil case numbers and the two felony case numbers. Okay. Your Honor, I'd like to bring up under NCR 2.614, there's an automatic stay provision. I understand the
Automatic stay provision on what?
on effectuating or executing on a judgment or order. Stay for 21 days from time to appeal of rights.
Counsel, you can read the rule anywhere you'd like. I'm not staying any order.
It's an automatic stay. I'm not asking you to.
Then I don't know why you're addressing me.
Okay, well,
I don't know about the provision. There might be an automatic stay in the provision. There might not. It's some obscure Michigan stuff. I don't care. But first she requests a stay of the order. And then he says, I'm not granting it. And she said, well, it's automatic. And he says, okay, why are you asking me then? Oh, it's good.
Second issue is then Mr. Miller decides to take an appeal. There's a second stay that must be issued. Would the court like me to address that now, or should I file?
I'm not issuing a stay. So you may address it if you'd like, but I'm not issuing a stay of my order.
Okay, and that would be the stay beyond the 21 days.
You need to file a motion regarding the stay, counsel.
Okay, that's what I want to be directed, and that will be a motion.
You know that. So I don't know why you're still addressing me.
Just allow me to do it orally, so
I am not. I want a written motion.
Okay. Thank you very much, Your Honor.
Thank you. With regard to the other matters, I will, because of this order, I will adjourn those matters, the felony matters. I'm not asking the people to do anything on that. Pending the final resolution of everything, I will adjourn those matters out to May 31st. I will also, and I do appreciate York Township being ready, but again, some of it's going to depend on what happens on the other thing. I will adjourn those matters also to May 31st. Unless there's an objection.
Can't speak for the township, but the people have no objection, Judge. Thank you.
Mr. Bernstein, any objection to the court in that regard?
No, Judge, Your Honor.
Thank you. Those matters are adjourned to 31st.
Well, there you have it. He gave his ruling. I didn't have a lot to say about it. The only thing that was funny is when the attorney piped in at the end with some really bad, arguments. First of all, she's not of record in the case. She shouldn't be talking at all. But he does while he's saying that, say, well, they have arguably some interest in an equitable sense. So he's being indulgent letting her speak at all. But that sort of ends the case. All these cases were on this special time. I don't know why this one was this morning. And they're going to enforce the prior agreement. So everything that she came in and did and whipped up and got her client to say that he's the owner, that's not happening. And we're just going back to as if none of that occurred and proceeding with the order as previously ordered. That's it. That's what's going on. He makes the finding that he is not the owner. That implicit in that is all the criminal charges against Mr. Miller will be dropped. So despite his horrible testimony and his attorney's horrible idea of claiming ownership of the dogs, he still stays out of trouble here. There are pending criminal actions against her. It looks like all that's set over till the 31st. I guess technically they're pending against him as well, but they're going to go if the court's making the finding that he's not the owner. So I still don't know what the resolution on the criminal charges will be for her, and I don't know if that will be on the call. I just don't know, but it looks like it's May 31st that it's all set over for. He probably wants to give a little time for this to shake out. She might file some appeal or something, but I doubt it. She tried to make an oral motion to stay. Of course you wouldn't. That's a intricate matter of law. Any judge would say no. Put that in writing so I can tell you with specificity why it's silly. But that's it. I felt compelled. I got pulled into the dog days, and then once we had this, although it didn't have super funny moments or anything, I felt compelled to show it because when people fall out, they want to see the conclusion, and that's the conclusion. While there's still collateral stuff going on, basically that ends the major issues in the case. So I appreciate it. I put that together. I was over on Legal Bites earlier. Early this month, I went on there twice today. That trails a whole situation. So I just wanted to get this in today because it happened today, and we've been following it here. Thank you all. I appreciate it. See you soon.